Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and the topic for today's video is the top 3 reasons real estate agents get commission complaints or sued, and how to avoid them. Or should I say tips to avoid them? Because I can't guarantee that you won't get sued or a complaint, but there's some things that we can do that you may find helpful. Alrighty, so let's go ahead and get into this. But first, I have to give a quick disclaimer. This is legal information. This is not legal advice. So for legal advice, you need to contact an attorney that is licensed to practice law in your jurisdiction. And all right, so here is the order of this presentation. So the first 3 things I'm going to talk about are these 3 big issues. And the first one is failure to disclose defects after identifying issues with the property, either during a walkthrough or during an assessment. The second issue is missing strict contract contingency deadlines, or perhaps just misunderstanding contract contingencies in general. And the third issue is what I call it, double-crossed by dual agency. That's what I call it here. And the fourth point I want to address is when to consider contacting an attorney if you are perhaps facing these issues or facing a complaint, or someone is threatening you with one. All right, so if you made it this far, you're watching on YouTube, please like and subscribe, because that'll help me keep making more of these awesome videos. Also, I have, and for people who don't like watching videos, I have an article version of this available on my website, www.tpf.legal. So here's what the written version looks like. So as you can see, there is a written version. Yeah, so that is for people who do not like to watch videos. All right, so on to the presentation. Alrighty, issue number one that gets real estate agents caught up and in trouble. That is failure to disclose defects after identifying issues with the property during the walkthrough or during the assessment. Alrighty, and not disclosing those defects to their, I guess in this case, it would generally be the buyer. But so, why is this a problem? So real estate agents have a duty to advise their clients of issues that they notice during their walkthrough or during their assessment of the property. So if you see something, you essentially have to tell your buyer that this looks off, or maybe this is wrong, or something's wrong for the property. See, and if it comes out that you did not tell them that, then they are going to be very angry with you, and they may have a claim against you if you did not tell them. So here are some potential issues for this, potential solutions for this issue. I said it backwards. So the first one is to keep a keen eye open yourself when you visit the property. And the second solution is to insist that your clients hire home inspectors and get property inspections done. I know some clients don't want to have they may not want to have home inspectors, or they may say, hey, I'm buying the property as is, why do I need a home inspector? Or whatever the situation may be, you definitely want to recommend that they always get property inspections done. Alrighty, issue number 2. This is probably the perhaps one of the bigger ones that I see, and that is missing strict contract contingency deadlines, and perhaps just misunderstanding contract contingency terms in general. So why is this a problem? So real estate contracts often have very strict contingency deadlines, and if missed, or perhaps if the contingency is simply just misunderstood, they could have significant unintended consequences. And here I have all right, so second point, I have the appraisal contingency example. So for example, in an appraisal contingency, it may say something along the lines of, let's say if you represent the seller, and they may be an appraisal contingency that says that if the property appraises for lower than the purchase price, then the buyer can notify the seller, and within X number of days, and then the seller has X number of days to reply to the buyer to say, hey, I'm not going to agree to lower the price. That contingency can say, could also say that if the seller does not respond within a certain amount of time, then the price automatically lowers to the assessed value price. Now, if you were to miss that deadline, then the price of the home would automatically drop. Now that could end up being that may have been intended by the parties, in which case great. But if it was not intended by the purchaser for that to happen, then they will be very upset with their agents, and their agents will be held responsible for staying on top of deadlines. So that's why you need to make sure you understand your the contingencies and that you are on top of them. But all right, so I have potential solutions here. So solution number one, I was just saying that, is either make sure that you fully understand all contract contingencies. So again, I use the appraisal contingency in my example, but this could also be perhaps even a property inspection contingency. Or whatever the other contingencies may be in the contract. They could all end up having significant unintended ramifications if not followed. And the second solution here is to set deadlines for all contingencies in a reminder app or a calendar app on your phone, so you get automatic notifications of these contingency dates so you do not miss them. And it's impossible to stay, especially if you're moving a lot of cases, it's impossible to stay on top of everything in just your mind. Maybe not if you might be one of those people that just have the super memory. But if you're normal like the rest of us, you're going to need an app to stay, or some form of external system to stay on top of everything. So make sure you have one, some sort of case management system. Alrighty, so number 3, and this is what I call double crossed by dual agency. So so dual agency is so first let me explain what dual agency is. So dual agency is that is when an agent is representing both the buyer and the seller, essentially. So why is this a problem? Well, for one, it may not actually be a problem because your jurisdiction may not even allow for dual agency. Now, the underlying problem with dual agency, it essentially comes down to the philosophical question of, or the underlying dilemma: can one man serve two masters? Like, can you go hard for both the buyer and the seller at the same time? Now, generally, you're supposed to go hard for, your client, and it's easy to go hard against an adversary. But if you have in a dual agency situation, I guess you would have the financial incentive to perhaps it kind of screws up the financial incentives in a way that it's not in a regular sort of agency transaction, right? So that's it. So here's how dual agency works in Maryland, because it's a little different than, because I guess Maryland kind of recognizes the issue with dual agency and having people represented by the same agent. So in Maryland, I guess perhaps a limited dual agency is kind of a way of splitting the baby, in a sense where you're allowed to have the same, dual agency, you're essentially not allowed to be represented by the same agent, but you are allowed to be represented by the same brokerage. So what they do in Maryland is so they can use the same broker, but then a broker will have one agent for the seller, one for the buyer, and they're supposed to try to advocate just as hard as they would as if they were not working under the same brokerage. I mean, that is the and of course, they have to make their clients their customers sign a consent form to allow this. But nevertheless, even with this, even Maryland style, customers still, in many cases, feel that their agent was not going hard for them, and perhaps they were caring more about their commission check than for them. Or in the worst possible scenario, they may think that that their agent was working against them and working for the other side. And perhaps what makes this scary is that may not even be the case. A lot of times in real estate transactions or deals in general, people don't get what they want, even if they weren't in a dual agency sort of situation. So it may not even be the case that they were done unfairly or not advocated for by their agent, but they may still feel that way. So here are potential solutions for the dual agency double cross. One would be to do no dual agency cases at all, but that's not It's not fun, but that is the solution, to just not do it. That is one way to avoid the elephant in the room. And the other way to do it is to directly address the elephant in the room in a conversation, to kind of let them again, you are required to do this in written form, but I don't think that that's enough to get the customer to fully understand what's going on. I mean, they probably don't read the contracts anyway, right? So I definitely think having a conversation and addressing the elephant in the room and explaining to them, how dual agency works, and and I have for point number 3, I have my, so I'm not exactly sure, how agents should go about talking to their clients. Hopefully you can talk to, maybe a broker or someone who can, tell you guys how to talk to your clients about certain things. I can't necessarily relate to you guys on that level, but I can kind of understand. So, because as an attorney, there are some situations where, let's say I will represent 2 people when forming the same LLC, for example. And that is a conflict of interest because, I essentially cannot go super hard for one person and then not go super hard for the other. These people are going into business together. There's lots of potential issues that could come up. And again, I cannot advocate hard for one and not go hard for the other, essentially. So I explained to them, hey, if you guys are going to hire me to form your LLC for you, and I understand that, you both want to agree to utilize me, but, there is a conflict of interest there, and that I cannot, and by doing it this way, I essentially cannot, prioritize one of you over the other. So in other words, I directly address the elephant in the room, educate them on that, make sure that they sign a waiver and all that good stuff. And then I'm good to go after that. So you definitely want to make sure that you have that conversation with your customers, your clients, and to make sure that you address the elephant in the room. All righty. All right, so the next and final point is when to contact an attorney when you are threatened with adversarial action. And that would be ASAP. I would say even before adversarial action is taken. So in a perfect world, I would have the opportunity to try to negotiate and resolve issues outside of court before complaints are prior to any sort of adversary. Sorry, I said in a perfect world, I have the opportunity to negotiate and resolve issues either prior to any adversarial action being done. So it's a lot less expensive to resolve issues outside of court or outside of the commission as well. It saves your time. It saves my time. You know what I mean? You don't want to go to court. I honestly don't feel like going to court either. I'd rather just stay home. Let's see, next point. Lawyers tend to have busy schedules. So again, that's another reason to contact an attorney as soon as possible. So the sooner you contact one, the better, so we can go ahead and fit you in their schedule. And I would know lawyers are very busy. And last point is you should consider developing a relationship with a cool attorney that is licensed to practice law in your jurisdiction, such as this handsome lawyer over here with less hair than me. And that's it. So if you have any questions that you would like considered from my Ask Attorney P series, you can visit my website at www.tpf.legal/ask. Now that is the specific link that will allow you to submit questions for this series. And thanks for watching. Again, my name is Brian Pendergraft of the Pendergraft firm. Contact me at tpf.legal, or you can shoot me an email at info@tpf.legal. Alrighty, take care and thanks for watching.